Is Brandon Raglin here? What's going on with Franklin Miller? He ever appeared?
He is not here.
He never appeared. Do you know if Mr. Eckridge had communication?
Make a motion.
I think you are. Did Alice Kane appear?
She's not.
Or you had communication?
I have not been able to reach her.
This is Robinson here for Dylan Morris. Was Mr. Lee here for Nicholson? Oh,
Jason Robinson was brought over. You know, Jason Robinson was brought over.
good access. Who got access?
Oh,
The court officer. Is Mr. Lee here? He was. Yeah, I don't know what it was. But where's he at? I don't know where they are. We're in here. This is Brian here? He's on Zoom, yes. Nicholson.
Yeah. Raglin.
Yes.
Your Honor, if you want Raglin. Ready.
Where is it? Where's Raglin?
He was on Zoom, I thought.
Who needs to return from the breakout room? Because he's not in there.
He's jumping.
Judge. Let's break out. April Straw. What is that? Are you handling April Straw?
Yes, Your Honor.
Okay, you prepared on hers?
I am, Your Honor. We would just be intending to continue.
Excuse me?
We would just be continuing to examine what would be.
April Straub, can you hear us?
Yes, I can.
Okay. Okay, my understanding is that we're continuing to exam on this next week, so we'll see you on the 26th at 9:30 in person.
Okay,
You're free to go.
thank you.
You're welcome.
Yeah, yeah.
On the record in the matter of the people of the state of Michigan versus Brandon Raglin, 26-00624 appearance, please.
Thank you, Your Honor. Randall Berman on behalf of the people.
And thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Mr. Raglin. He appears with us remotely via Zoom.
Can you hear us, Mr. Raglin?
Yes, I got an Android, so please work with me. Yes, I can hear you guys right now.
I don't know what that means. You got an Android, what does that mean?
An Android phone it's not like an iPhone, so sometimes the connection might be a little staticky.
Okay, well, you chose to appear via Zoom. It wasn't mandatory. You could have appeared in person. So if it doesn't work, you can come in person.
Yes, ma'am.
Today was a date scheduled for probable cause conferences for controlled substance delivery, manufacturing. Matter is scheduled for a preliminary examination on the 26th at 8:30. My understanding is that the defendant does not wish to have an exam.
That's correct, Your Honor. It's my understanding defense wishes to unconditionally waive the preliminary examination. The people also unconditionally waive their right to a preliminary examination. The offer that's been set or provided to the defense for the waiver is 2 counts of possession less than 25 grams in circuit court with negotiations to continue.
Mr. Austin.
Thank you, Your Honor. That is correct as to Mr. Ragland's intentions. That's also correct as to the status of the current plea negotiations.
Mr. Raglin, you do understand that you have the right in this matter to proceed to a preliminary examination on the charges of controlled substance manufacture delivery, counts 1 and count 2, less than 50 grams, correct?
Yes, ma'am.
You also understand that you have the right at the time of your examination to have the prosecution establish that they have sufficient probable cause that those felonies were committed, and then sufficient probable cause to charge you as the person who committed those crimes. You understand that?
Yes, ma'am.
And you wish to unconditionally waive your examination?
Yes, ma'am.
Okay, and so no one's forcing or threatening you to get you to do that, correct?
Correct.
Okay, your bind over date is gonna be April 1st. That's the date the circuit court's receiving this file, not a court date for you, okay?
Okay, am I supposed to show up in person or just
I
talk to my
literally
attorney?
just said that's not a
No.
court date for you. I said that's not a court date for you. That's the date that the circuit court's receiving this file.
Okay, I'm sorry. I didn't understand. I'm sorry.
Okay, your next court date will be a pre-trial. That date will be set after they receive the file. Your attorney will be made aware of that date, okay?
Okay.
I am unsure if that date will be, you would be required to appear in person or not. I'm not sure, but I do know when you appear, it is your responsibility to appear with an appropriately named device. Do you understand that?
Yes, ma'am. I do want to apologize to the courts too, is that as well, because I didn't even know my name was set as that. I didn't know. My kids must have did that. I promise you.
Okay.
I promise
You're
you, I did.
also the picture on your device. You
I
should
seen that
remove
as
that.
well, but I was trying to
It's not
change it. I
appropriate.
promise you, I was trying to change it. I promise you, I seen the court. I'm like, oh my God, this picture. Oh my God. But I appreciate it. I apologize to the courts. I'm so sorry.
Okay, so again, I don't know if your next court date will be in person or via Zoom, but your attorney will know more information after the date is set. Your bond is set at 3,000 personal recognizance. That will continue. Any additional matters for the record?
Not on behalf of people, Your Honor, thank you.
No, Your Honor, thank you.
Thank you, you're all set.
Thank you. You guys have a blessed day.
I didn't know if I put it on there. Thank you. Okay, let's see. Someone just logged in from jail. Who was that? Mr. Morris? No, Mr. Morris was already here. Sir,
No,
who is
got
it
it.
opposed to? What's your name?
God's chalk, man.
Wesley Dodge. Oh, okay. Well, is Miss Robinson? Do we know who Miss Robinson is?
I changed, Sheriff's Robinson.
They can't both be on the record at the same time.
Let's dismiss.
Excuse me?
I think we sent a nollie for God's sake. Let me double check. Yeah, it was nollie. It was wrapped up with our 55th case and then we submitted nollie.
It may have been the intention for it to be Nolly.
Huh.
But it wasn't.
Well.
Sounds pretty good. Mr. Goschalk, I believe your matter was dismissed per another agreement, okay?
Yes, ma'am.
You're all set.
Thank you.
She's seen it. No, it's
Okay, gotcha.
I think it probably was just sitting and neither one of us were here. So, Mr. Lee,
Yes, ma'am.
you have Nicholson
Yes, ma'am.
on the record in the matter of the state of Michigan versus Edward Nicholson, 25-02278 appearance, please.
Hannah Buckingham on behalf of the people requesting to practice under Michigan Court Rule 8.120 under supervision of Assistant Prosecuting Attorney Dan Smith.
Permission is granted.
Assistant Public Defender John Lee appearing on behalf of Edward Nicholson. Ron. Mr. Nicholson is not present.
He is on my Zoom.
Oh, he is on the Zoom. Okay.
Mr. Nicholson, can you hear us?
Yeah.
Can you start your video, please?
Word, not now.
Okay. I don't know if we
He may have to log into
know
another.
time. I don't know if you know how to start this video. I'm going to proceed without the video at this point. Today was a date scheduled for a competency evaluation. The court does have a report that does indicate it was dated for February 26th. Counsel, you both got a copy of that report?
Yes, Your Honor.
Yes, Ron.
Okay, the opinion or conclusion of the report at this time is that the defendant is not competent to stand trial, and that the examiner's opinion that he's not restorable to mental capacity that will allow him to aid in his defense in a capable manner. Any reason to object to the findings of the report?
Your Honor, as far as the actual substance of the report, we have no reason to object. There are concerns just about the continuing issue with lack of letterhead, knowing the source of report and detail of the examination, but as far as the conclusion, we have no reason not to defer.
I would agree. I don't understand why I'm getting reports without letterhead. This might be the second. I think that was why I reset this. It's exactly why I reset it. Because there was no letterhead. We don't even know who performed this report. Was this from the forensic center?
This was Dr. Quinn Thomas.
I know that because he signed it. Is he from the forensic
He is
center?
independent. He is independent.
That's
He's
like-
not with the forensic center.
And that's the issue that we would have is
Who
it's
ordered an independent evaluation?
We did, Your Honor. We came to court, just to backtrack to where this started. We came to court. The court ordered a competency evaluation. We went to CFP. They found him competent. We came back to court and attempted to put a plea on the record. We were not able to get past the advice of rights. It was clear that he was.
Oh,
not
okay. I do see where there was an independent evaluation for this. Okay. I vaguely remember. Okay, and so the basis of the people's objection is that there's no letterhead.
is not knowing the source of the testing and the actual clinic that performed it.
The source of the testing.
Yes.
Mr. Lee, are you able to contact this entity to have them place this on a letterhead and provide us that information?
Yes, I will.
So I think that was why this was reset in the first place.
I did just, I don't want to throw Dr. Thompson, but I did request it on letterhead. I got the feeling that when we got back from his vacation, that he was very busy and this is what he sent me. I will go back to him and let him know that that's not acceptable for a court hearing.
When he got back from his vacation, he was very busy. To put something on letterhead, the printer does all the work. It doesn't take that, the report's already prepared. I don't see why it can't be printed on letterhead. And I would imagine, I don't know, but a psychologist operating in this capacity probably has an assistant. I don't know though. Someone else that probably puts things on letterhead for him. If not, if he does it for himself, it's still his responsibility, and coming off vacation and being busy because he's just on vacation is not a reason for me to excuse the lack of professionalism in his report. And so at bare minimum, if he wants to submit a report to the court for consideration, he needs to have it, be properly credentialed, but then also he needs to have it on a letterhead so that it looks reasonable. Anyone could have done this.
Stated, Your Honor, that's the only issue we have is just the reliability is brought into question because we don't have a way to check the source. Other than that, no questioning of the substance. Thank you.
Okay, so we'll adjourn this for the next available court date. It shouldn't take him long to reprint this with the appropriate indicators and provide a copy to the prosecution and defense in the court. Any additional matters for today's record?
Not from the people.
Nothing for the defense.
Thank you. We're all set for today, Mr. Nicholson.
Okay, thank you.
What date?
March 26th at
Okay.
9.
Let me reset this for March 26th at 9.
Okay.
Thank you, Your Honor.
Thank you.
Yeah, Marshall.
March 26th at 9. Where did Mr. Lee go? Did he have another one or is that it? I think that was it. Got it. Okay, I see Ms. Robinson. Ms. Robinson has
Mr. Morris, Judge.
Mr. Morris. Are we ready for him?
We are.
State of Michigan versus Dylan Morris, 26-00098. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Dan Smith appearing on behalf of the people of the state of Michigan.
Aaron Robinson, Assistant Public Defender for Mr. Morris.
Okay, Mr. Morris, you can hear us, correct? Today was the date scheduled for a sentencing. I do have a pre-sentence report that was prepared on the 10th of March. Council, you got a copy, correct?
I did.
We also received a copy.
Any reason to make corrections up to the commission?
The defense has none.
We have nothing.
Yes, Your Honor, we asked that the court follow the recommendation and sentence Mr. Morris to time served. I believe he has 66 days according to the report. While in custody, Mr. Morris has taken advantage of some of the programs that the jail has to offer. He's gotten in contact with cats and has completed some AA and intends to continue with that, the cats and the CMH programming once released from custody.
That does indicate that he does obviously have some detainers or other pending matters at this point. I think he was supposed to be on probation for 2 years, I think, out of Plea County. He's got credit for 66, well, yeah, 66 days in custody. I'll give him credit for that time in lieu of probation. Any additional matters for the record?
Nothing from the people, Your Honor.
No, Your Honor, thank you.
Oh, you're all set, Mr. Morris.
Yeah. So what, I didn't hear what she said, probation?
I guess you have credit time served.
Okay, thank you.
You're welcome. Ms. Robinson, you have another matter?
I do.
Oh, no, that was dismissed. That was Gus Shaw. Was Jason Robinson brought over?
We don't have a check for that card.
Who represents Jana Wallace? Are you ready on that one?
Oh, Your Honor, she on to.
She is here. Ms. Wallace, please start your video. State of Michigan versus Jana Wallace, 26-00492, appearance, please.
Anna Buckingham on behalf of the people.
And thank you, Your Honor. Good morning, Jared Austin, appearing on behalf of Ms. Wallace. She appears with us remotely via Zoom.
Ms. Wallace was scheduled for a probable cause conference. Today, this matter is scheduled for exam on the 26th at 10:30 with an extortion charge. Are we continuing to exam?
Your Honor, my understanding after speaking with Ms. Wallace is she wishes to retain her own counsel, and she's in the process of doing that. So she would be requesting an adjournment of the preliminary examination in order to facilitate that. She is willing to waive the timeliness or the 21-day requirement in order to do that.
If you take a week to retain counsel, she can appear next week with her counsel. Okay?
I haven't hired anybody yet, so I just talked to him
Yes.
yesterday on the phone.
You have a week. So they can appear next week with paperwork so that they can appear. Because once they come on this case, they have to do a substitution, which requires your current attorney to sign off on it, and I have to sign off on it. And so you got a week to do that. If we need to address the timeline, we'll do that next week. I'll treat next week as another probable cause conference. No witnesses are required to appear. But you, ma'am, will appear next week with your attorney or with information about who your attorney is going to be, okay?
Yes, ma'am. Yes, Your Honor.
Any additional matters for the record?
Not from the people.
Not at this time, Your Honor. Thank you.
Thank you. You're all set.
Jason Robinson, they didn't bring him over.
Mr. Austin, did you have another one?
I have Mr. Wade, Your Honor. He's in custody in Clinton County. He's downstairs. I was unable to talk to him earlier. There's been a misdemeanor offer extended to him this morning. I think based upon my prior discussion, we'll likely have a resolution.
You said you were not able to talk to him, or you need to, or you did talk to him?
I've spoken with him previously.
I mean,
wasn't able
about
to-
the new offer.
No, because it was just extended this morning and there were no rooms available.
We can bring him up. We'll give you an opportunity to talk to him.
but I anticipate we will likely have a resolution.
Okay, sounds good. Let's see, Ms. Wanji was here, but I don't.
Break our rule, Mr. Gwynn, Terrance Wade.
With who?
Gwynn.
Okay.
Terrance Wade.
Elena. I forgot what was the jury room.
Oh, yeah.
What's your name? Excuse me? Can you stand up? It's not picking up your voice.
Right, that part?
Thank you. Which charge are you looking for?
Or the cameras, it's Brett.
Buchanan's docket. I think you're supposed to be in Judge Buchanan's courtroom.
Her files are right there.
Oh, am I doing her
Yes.
PDCs? Oh, okay. Well, that makes sense. Who's representing them? Oh, let's put them on top of these other files, that's why. Okay, let's see. What was his name? Brett Kephart? What happened to these other matters? Those are the probation. I think they need it. Probation. Her sobriety. Oh, she did her sobriety? Yeah. Oh. Mr. Goodrich is handling this. Do we know where Mr. Goodrich is? Oh, he's asking me.
Jana, I just got on Zoom.
Oh, okay. You need to meet with him?
Yes, please.
Okay. Let me see, I just alerted somebody. Oh, I'm confused. Who's J25?
That's me.
What's your
Jeremy
name?
Wesley. Jeremy Wesley. Can you hear me?
I can hear you. That's Mr.
Okay.
Stokes. Oh, where can you spot this thing? What is it? This looks like it's this Buchanan's file. She can find all that stuff. Yeah. That's all. Being quite early, this is attorney gonna come in, sir. Right. Did your attorney tell you to log in this early, sir?
Well, I know my appointment, it was at 10 o'clock, right?
I have it scheduled 10:30 before Judge Buchanan. We're happy to
Okay.
handle it now. We just need your attorney.
I thought it was 10 o'clock. I'm sorry.
Well, if you want to message him and tell him you're logged in, he can log in and we can get this taken care of right now.
Okay, let me see if I can do it while I'm on Zoom. Uh-oh. Nope. I can just come back at 10:30.
Sounds good.
Okay, thanks.
Mr. Goodrich, are you ready?
Yes, Your Honor, we are going to be leaving that matter set for preliminary exam next week.
Right. Oh, that's Mr. Kephart?
Yes, Mr. Kephart, yep.
What you say? I didn't hear you. You need to talk to your client. Is that correct?
Yes, I've already spoken.
Oh,
We're ready
okay.
to go. Whenever the court's ready.
There you go. Okay, Mr. Kephart, can you hear us?
Yes.
Okay, looks like you are scheduled to see Judge Buchanan on the 26th in person for your examination on assault with intent to do great bodily harm, less than murder. There's a domestic violence half second and then a bond violation. So you'll see her next week, okay? You're all set.
Thank you, Your Honor.
Thank you. And then Mr. Goodrich, did you have another one?
Yeah, could I speak with Kyle Keys, who's in post 2, visit 5?
Mr. Kephart, you're free to go.
Thank you, Your Honor. Have a lovely afternoon.
Thank you. Who's representing Mr. Nguyen? She has 3 sentences. Where's Ms. Wanji?
Fast. I see her, she's in that room talking.
Exactly, she was gone.
Yeah, oh, wow.
Yours is very focused now. We don't have to wait for her to talk to her client. You're supposed to talk to your client before now. Okay, on the record, who is this here?
Mr. Wade.
On the record in the matter of the state of Michigan versus Cedric Wade, 25-03236. Terrance, please.
Thank you, Your Honor. May I please report Assistant Prosecutor Dan Smith appearing on behalf of the people of the state of Michigan.
Thank you, Your Honor. Good morning, Jared Austin, appearing on behalf of Mr. Wade. He stands present to my right. And Your Honor, may I approach?
You may. Mr. Wade was scheduled today for, thank you, a probable cause conference. Is that correct?
I believe, Your Honor.
Oh, he's scheduled for prelim today. Let me look at my document, not just. He was scheduled for a prelim on home invasion, second degree. It says that people are offering a plea to amend count 1 to entry without owner's permission. Add a count 2 of larceny, 200 or more, but less than 1,000. Is that correct?
Yes, that is the offer that we extended.
So the defendant would like to accept that offer? Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under the penalty of perjury?
Yes, Your Honor, I do.
Thank you. Put your man down. I have an advice of rights and information sheet. Is this your signature?
Yes, ma'am.
And you went over these rights with your attorney?
Yes, Your Honor.
Willing to give all of these rights up today?
Yes, Your Honor.
So you understand that you, as you stand there, are presumed innocent until proven guilty. and that you can take this matter to trial and have the prosecution prove your guilt by proving each element beyond a reasonable doubt. You have the right to see, hear, or question any witness called to testify against you, the right to call your own witnesses to testify on your behalf, the right to subpoena or present evidence that you believe show a defense to the charges, the right to remain silent and not have it be used against you at your trial. You understand that? And you want to give those rights up. Anyone promising you anything to get you to plead guilty to these amended charges?
No, ma'am, they didn't.
Anyone threatening you to get you to plead guilty?
No, ma'am.
You're not on probation or parole, correct?
No, ma'am.
You understand that a guilty plea can result in the conviction that you may need to report to your current or future employer.
Yes, ma'am.
It also could have impact on where you can travel or get immigration status.
Yes, ma'am.
Are you looking to plead to these charges because you believe you're guilty of them?
Yes, ma'am, I am.
As to amended count 1 of entry without owner's permission, how do you plead? As to added count 2 of larceny, 200 or more, but less than 1,000, how do you plead?
Guilty.
Factual basis, counsel.
Yes, Your Honor. Mr. Wade, I want to take you back to the time of August the 6th of last year, 2025. Is it true that you were at or near the location of 4620 South Martin Luther King Boulevard in Lansing, Michigan?
Yes, I was.
Is that here in Ingham County?
Yes, it is.
That was a residence or a dwelling of some kind?
Yes.
And is it true that you entered that residence without the permission of either the owner or the person who was lawfully staying there?
Yes, sir, I do.
Okay, and at the time you entered that residence, is it true you took some items that didn't belong to you?
Yes, sir, I do.
And that was an Xbox or some gaming equipment, is that correct?
Yes, sir.
Okay, and the value of those items would have been somewhere over $200, is that correct?
Yes, sir.
Satisfactory, Your Honor?
Satisfactory. Any questions for you?
No, people are satisfied.
I find your plea to be freely, voluntarily, and intelligently made. Let's see, it's only at an interim bond. I don't know, when this is interim bond. I'm trying to see if he has credit on it. No, close to the bond, I think I see the bond here. 500 cash.
It was 500 cash.
Yeah, he paid 500 cash. Do we have a victim here today?
We do not have a victim.
Oh, I was gonna send it. The victim's not here. Is there restitution at all in this?
We are asking for restitution for the items that were stolen, which is an Xbox and Xbox controllers.
Why is the victim was not subpoenaed for exam today here?
The victim was not able to make it today. He's out of state.
So the victim was subpoenaed to be here today for an exam?
Sentence. It was prepared by our office. I don't show that it was returned.
You mean, what do you mean it was returned?
I don't show that we have any service.
Oh, so I'm just really unclear. Do I have an exam scheduled for today? Which means the victim's supposed to be here. But then there was no preparation for the victim to be here. I'm confused. Because we gotta pay to rid him back here.
Well, we were gonna make an offer. We believe that he was gonna accept that offer. If he did not accept our offer today, we were gonna dismiss and refile when the witness was able to make it to court.
And when will the witness be able to make it to court?
I believe he's gonna be back in town. He's at work. He's on a working trip that took him to South Carolina. So he's planning on getting back next week.
Okay, so your office had information that he was supposed to be gone today for work.
Yes.
Not that he lives out of state.
No, not that he lives out of state.
And so he's supposed to be back when?
Supposed to be back sometime.
And he's being held on something else, obviously, in Clinton County.
He's serving a sentence, Your Honor.
For how long?
His out date is projected to be July the 25th.
I gotta set it. My sentencing is gonna be May 7th at 9 a.m. I'm not requesting, yeah, sorry, 'cause he's gonna get credit time server, might as well be clear on that.
So you want just the sentencing date?
Yeah, just a sentencing date. And then, I'm only setting it out because I need to see if there's restitution and victim impact statement. Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing additional at this time, Your Honor. Back.
You're all set for today.
Have a wonderful day.
Thank you. Okay, and then we still don't see Miss Wanji. Maybe on your walk by, you can yell her name in the hallway. Let her know that she was scheduled for sentencing at 9 o'clock. It's 10:08. Mr. Goodrich, are you ready with someone?
Yes, I'm ready with Mr. Keys.
State of Michigan versus Kyle Keys, 26-00662 on Judge Buchanan's docket, council appearance.
Ross March, meet up for the people.
And Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Keys, who's appearing from jail over Polycom today.
Mr. Keys had a probable cause conference scheduled before Judge Buchanan today for assault with intent to do great bodily harm and assault with a deadly weapon. There's an exam that's set for the 26th at 9:30 in person. Are we continuing?
Yes, Your Honor.
Okay, any additional matters for today's record?
Yes, I would just note that the people have extended an offer to the defense that would require a felony plea in district court. We'll do our best to give the court advance notice if he decides to avail himself of this offer, and I have explained that if it goes to the circuit court without there having been a plea in district court, it will likely be going with several additional felony charges.
And that's been made clear to your client, correct?
Yes, Your Honor.
Okay, and does Mr. Keys have any questions for the court at this time?
Your Honor, Mr. Keys would like me to address bond if possible today.
Okay,
Oh, well, I'm sorry.
proceed.
Okay, thank you, Your Honor. Your Honor, Mr. Keys was charged, has these two felonies currently pending. Bond was set at 40,000 cash or surety in this matter. We would ask the court to consider just reducing that to 40,000, 10% with a GPS tether. I think that would provide sufficient protection for the community. He has a stable address. So we would just ask the court to consider reducing the bond so that perhaps we'd be able to post it with a bondsman. Thank you, Your Honor.
Let's see, are the people responding?
Yes, Your Honor, the allegations in this case involve beating a woman with a flashlight, running her with a knife, and setting her running down the street unclothed at 6 in the morning. I think that a $40,000 bond in light of these circumstances is pretty generous. She wound up giving her statement to the police in the hospital because the beating was so severe. I think that 40,000 cash surety is appropriate in light of the evidence in this case.
In addition to that, I'm reviewing the criminal history report that was attached to the bond recommendation, or I should say pretrial services release report. And the defendant does have a extensive criminal history that has quite a bit of assaultive actions on it. I think the bond as set was appropriate. It will continue. Any additional matters for the record?
No, Your Honor, thank you.
You're all set, sir. That was Mr. Keys. Mr. Goodrich, you had Martinez. I don't know if he's here though.
Let me go, I'll go see if he was planning to come in person. I was planning to turn in a report to have him evaluated by the Forensic Center, Your Honor. Should I
What's your name, sir?
come in and hand that to your staff?
What's your name? He's here.
Okay, I'll be there just a second.
Thank you. So I don't know if it's an update that they did on my work phone, but it's screening the calls and I'm here for it. Before it lets it ring, the phone is telling it, it must tell me who it is.
Oh, yeah, that's the new.
And so it says this was somebody from the Attorney General's office, and I love that it's screening that.
She's standing in front of your store. I'm gonna walk in there.
I know you lying.
Yeah.
I know you was lying.
I'm gonna walk in there.
I know she don't got 50 million people in here waiting for her and she's in Flores's.
I just have a picture and she's standing up at work.
I see. Hey. Today is my day. I just spent a whole hour trying to control myself after having a whole emotional breakdown. Today's not the day. No, every time I was I promise you.
Approach with the Forensic Center.
Mr. Nguyen, I was muted. Mr. Nguyen, can you hear me? Okay, we are on the record in your matter. I have a pre-sentence report prepared on the 11th of March. And counsel, did you get a copy of that?
I did, Your Honor.
Do we need to make corrections, updates, or deletions?
No, Your Honor.
Okay, it looks like he has a lot of time or credit for time here. At least at the time of this report, he definitely was at almost 90 days. Let's see. We can make allocation.
Thank you, Your Honor. And I have discussed with my client, and it's my understanding that we don't have any corrections. He is very he talked to the probation officer and was very truthful about his problems. He report that he has some issues with housing. At the jail now, and he has a lot of days that he credit. He's willing to try probation, even though that's not the recommendation for probation, but he's willing and he's ready to try probation. He believes that the time that he spent in jail had allowed him to become sober. He also availed himself to the PATS programming, and so he is ready to be sent home. So I would ask the court to allow him to get out of jail critically for the time that he already served. Thank you.
Does your client want to make a statement? Mr. Nguyen, did you want to say anything to the court?
I apologize for the holding time that you have.
Okay. Another matter that's pending before me, correct? Looks like 260361. It's free trial on the 20th. What's his bond on that? Okay. My concern with him is he doesn't come to court. That's why I'm dealing with the 2023 case in 2026. Not because there was any delay in the prosecution, but Mr. Nguyen doesn't like to come to court. And there was originally a killabrew at the time that the plea was entered in 2024 for credit time served. And at the time, he had already accrued time, but since then, he's accrued more time because he keeps failing to appear. So I am going to sentence him to 93 days Ingham County Jail, credit for the time served, which I do believe he said 89 days right now. I'm going to remind him that he needs to appear in court for his next pretrial, because he's going to be released before then, because he has a PR bond on the other file, which means he's not accrued any time on that case. And so you've got a pretrial before me on April 20th. Do you understand that?
Yes, ma'am.
You need to appear for that, okay?
Yes, ma'am.
Do you have any questions at this time?
No, ma'am.
You're all set. Thank you.
Thank you. This case is over.
This case is completed. You have credit for 89 days, so you'll be released after you get to your 93 days.
Thank you. Thank you.
You're welcome. Let's see, I thought I see Mr. Oaks here. Mr. Oaks, are you there?
I am here, Your Honor.
Okay, State of Michigan versus Jeremy Wesley, 26-00313, appearance, please.
Ross Marchman on behalf of the people.
Mike Wilkes appearing on behalf of defendant.
Jeremy Wesley is present.
Present.
He's present via Zoom. Today was the date that was scheduled for a probable cause conference for possession of controlled substance before Judge Stacia Buchanan, and there's a prelim scheduled before her at 10:30 on March 26th. Are you continuing to exam?
No, it's my understanding defense will be requesting an adjournment. They recently put in a request for some additional evidence from the police regarding background on the canine that was involved in this case. So we need some time to get that for them. And I will note, we've extended a misdemeanor offer that during the interim period, the defendant will consider. So the defense is requesting an adjournment, the people don't object.
That's correct, Your Honor. I requested additional discovery regarding the K-9, also video evidence of the traffic stop and subsequent search. So we're requesting an adjournment. I've talked to my client about his right to have his prelim within 21 days. He understands he will hereby be waived. He said right.
Is that correct, Mr. Wesley?
Yes, that's correct.
Okay, the court will accept your waiver and recess this matter.
Thank you, Your Honor.
Let me get your new date for another probable cause conference. Did they give you these dates? Yeah, okay. So March 27th at 9:15. It says March 27th at 9:15 is the new probable cause conference date.
Okay.
An exam April 9th at 10:30. An exam April 9th at 10:30.
Thank you.
No problem. Any additional matters for the record?
No, Your Honor.
Thank you.
You're all set to leave, Mr. Wesley.
Okay, thanks.
State of Michigan versus Donald Slater, 25-03836, appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith appearing on behalf of the people of the state of Michigan.
Good morning, Your Honor. May I get everyone from Mr. Slater, who is by my side at the council table.
Robinson is here.
Robinson is one, he's down in jail.
He's in the jail.
Yeah.
Did Nick talk to him already? Okay, today was the date scheduled for sentencing. I do have a pre-sentence report that was prepared on 13th of March. Counsel, did you get a copy? Do we need to make corrections, updates, or deletion?
Only to the fact that my client reported that he did avert himself to a substance abuse assessment, and the provider was supposed to mail it to the probation officer, email it to the probation officer, and it is my understanding that that was done, but it's not reflected here in the PSI. But he did say that he did the substance abuse assessment. That's the only correction that.
When did he complete the assessment?
March 6th.
Well, defendant was advised to complete a substance abuse assessment and have it turned into probation department by March 2nd. So if you don't do the assessment until the 6th, how can you turn it in by March 2nd?
Nathaniel Reeves extended that for you
When did he extend that?
prior to March 2nd.
He didn't put that in the report. He didn't write this report until the 13th. What took so long to get an assessment done?
I had private health insurance, so I was having difficulty finding someone that would accept that and not Medicaid. And I did come in multiple times to talk to Nathaniel Reeves, and he gave me till the 6th.
Okay, and so it's been completed, but it's not been turned over? The report?
Yes, ma'am. I gave the lady that did it at CMH's card, even checked with her before I left and was like, you're gonna email it today, right? And I called him when I left there and told him that they were gonna be sending it to him on that day. I was surprised that I didn't hear from him when he didn't receive it today when I saw the report.
Okay, any other changes?
No, yeah,
You can make allocation.
thank you. And my client was very forthcoming, and even the reports stated that with his issue, with his problems, and he said that he was very depressed at the time, and went back to using. Since that time, he has been seen. When he went back to CMH, he's doing better. He has no urges, so he believes that any recommendations from the substance abuse assessment and any requirements from probation, he would be willing to go. Would not be a problem for him to follow those recommendations or to abide by those requirements. I do believe that he is a good candidate for probation. He's employed full time. He is back at home with his family. He's following the programming, and actually he is doing therapy already on his own. So we would respect it as the court to follow the recommendation from the PSI and give information.
Did your client want to make a statement?
I own my decision, Your Honor. All I can do is move forward and learn from it, and that's what I plan to do. I gladly accept whatever the court recommends.
The report recommends obviously completing the substance abuse assessment and following all the recommendations which you've indicated to the court that you have completed. We just don't have the report. So it's your responsibility to make sure that report is turned over to probation. And it needs to be turned over immediately so that we know how to properly fashion your programming. And we don't really know that right now. I am going to order 10 months of probation at this time. While on probation, you will be required to maintain your employment. You're not to be at any bars or nightclubs. You will be required to submit to random preliminary breath testing and your analysis testing. You have to pay the cost of that. I'm going to order that you participate in substance abuse treatment as recommended, and that you not engage in any assaultive or threatening behavior. Do you understand that?
I do.
You do have a $30 per month oversight fee for each month of probation that you will be responsible for. If you do 10 months, it's $300. There's a $75 crime victim rights fee that will be assessed, plus a $50 state minimum cost. That will be assessed. We're going to waive discretionary fines and costs at this time, okay?
Thank you, Your Honor.
There's an advice of rights as to when you and how you can be released from probation early, but it's not in my file. So someone's got to provide that. You have the right to request early discharge from probation once you've completed half the term originally ordered by the court, so long as you've not had any violations within the 90 days preceding such request. You would use the court MC 512 form. That's on the court website. You can get it from the probation department. Once you complete that form, you file it with probation. You must serve a copy of it on the prosecutor's office. The prosecutor has 14 days from receipt of that notice to file any objections in writing to your request. If it's set for a hearing, you have the right to hire an attorney to represent you for that hearing, but you don't have the right to have Ms. Wanji or another public defender represent you for any hearing for early discharge. I've never had a hearing for any such request. Not saying I won't, just so far, all of those requests have been able to be resolved without a hearing. And so it's likely that you won't need a hearing. Do you have any questions so far?
I don't, Your Honor.
Okay. And so you would be eligible to make such request if you complete all your programming, you've had no violations for 90 days preceding the request 5 months in, okay?
Yeah, I understand.
Probation officer also could go ahead and complete the request on your behalf as well. You'll check in with Mr. Neves before you leave today. Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing for the defense.
Thank you, you're all set.
Thank you, Your Honor. Have a good day.
I'll meet you.
Thank you.
Meet you.
And then after you do that, David, when you take him down, can you bring up
Wallace.
yes, please.
Yeah, I'll meet you.
Is Raglin Wheaton here?
She's.
You didn't see her today?
Wait, I have not seen her today, but yesterday when she called, she was having some kind of issues. She was on her way to the ER. She had also called on Saturday, left a message for me, telling me about this, her issues. I tried to call her yesterday. I was not able to reach her. She usually is good being in contact with me, but I do understand. I do know that she has a lot of health issues.
They'll drink you for 48 hours, but then it'll be issued in case you get in contact with her. That's all I have for you today. Did you have anything before Judge Buchanan?
No, you're not.
Okay, thank you.
Thank you.
Mr. Goodrich?
Yes, Your Honor, I needed to meet with Elmer Salvador Regaldo, who with an interpreter. That might be him in post 1 visit 3, but I'm not positive.
That, I believe so. Sir, what's your name and ¿cómo se llama?
Elmer Javier Salvador Regalado.
Thank you. You can put them in the breakout room, please. Mr. Goodrich, who are you ready on?
I'm ready on Salvador Regaldo. The interpreter and my client must be making their way back from, well, I guess it probably needs to be, there's the interpreter. I probably need to close the breakout room.
Yeah, he
Interpreter,
was asking for like a question at the end, but that's not the beginning.
he
That's
had
like I have a
question.
question, but he had a question at the end.
For the attorney?
Yeah.
Okay, if you all can go back to the breakout room, I'm gonna move you to room 2.
Okay.
This is Mr. Robinson. Okay, State of Michigan versus Jason Robinson, 25-03246, appearance, please.
George and Ed. Oh, sorry.
Thank you, Your Honor. May it please the court. Assistant Prosecutor Dan Smith, appearing on behalf of the people of the state of Michigan.
George and Ed, APD on behalf of my client or Mr. Etheridge's client, who's standing to my right. And or.
They was scheduled for a sentencing. Just trying to see when I could. What did he plead to? A note in here of what he pled to. There's no plea sheet.
Your Honor. if I
Oh, wait, the
may-
plea sheet's over here. I think it was an unlawful use of motor vehicle.
That's
And
correct.
a
And
domestic, or the
domestic violence, and there was a no low content plea to the unlawful use of vehicle.
And I honestly did not refer him to probation because he's in custody, correct?
Correct, Your Honor, he gets released June 5th. There was some mention in my notes, I don't know how accurate this is gonna be, but to run, my client indicates that it was a time served sentence, agreement. I have something regarding a concurrent sentence with this Kent County case.
Yeah, it does say people consent to concurrent sentencing,
Okay.
not time served. There was no objection to immediate sentencing, but I'm assuming the victim was not present. It's probably why this was reset. Any allocution?
Your Honor, Mr. Robinson gets out, to my understanding, June 5th. I'm asking for a time served sentence since he's gonna be in custody regardless. I don't know whether there's some kind of special status he may get by having this case closed out. A good time. I don't know, the individual who is allowed to be in or around the prison. Like the individuals who can, you know what I'm talking
You
about?
mean so that he can be a trustee?
That's the word I was looking for. So we're trying to see if we can do a fines and cost sentence today. He doesn't get out to June 5th.
Do you want to have fines and costs? What are you saying?
Yes.
Why?
So.
He's like, no, you don't want fines and costs, do you? You want credit time served.
Yeah.
Credit
well,
time served.
That's what I think.
Thank you. You're all set.
Thank you.
Oh, wait, but Your Honor, can you see there's a warrant right now? There's a case I was indicated that he might have a
From the
warrant.
16th of July. They said they come bring up the
From the
case.
16th of July.
Yes, they trying to go back in and bring up the case on the 16th of July.
At this court?
Your Honor, I'm
Like
seeing,
a reissue, maybe, you mean?
No, just the 16th.
Because why would we not have addressed the warrant by now? From the,
Clearly, they sent a strangulation case.
Your Honor, I see it as not assigned to a court yet, but we do have an issued complaint already for that case, but there's no
Same
other
victim.
information about dates or anything. in our
this
system.
court?
And it's assigned to 54A. It says that we have charging documents that were issued.
Same victim too.
Complainant.
Who signed it?
I got his name in my pocket.
No.
Adam Pfeiffer.
No, I mean the
Oh,
the judge. It's been signed by a judge?
no, that's what I'm worried about.
If it's not been signed by a judge, it's not issued.
But that's the problem, like, if I.
He's been in for 10 months, Your Honor.
Yeah, I'm about to be in 10 months, and if I get out the door on June 5th, and then they arrest me again at June 5th for the same victim for a charge that's.
I understand your concerns, sir. I get your, listen, I understand your concerns, but we gotta calm down.
I'm just
Are you doing some anger management in there?
No, I'm just ready to get
You
my
need
life
to
back
be.
on, okay? Well, that's a good
Just
recommendation.
so you can know, understand that you can be angry, but know how to manage it.
Yes, ma'am.
Okay, let me see.
I'm being told that the warrant needs to be sworn to. It's been, the case was filed, the district court is the last note I have.
I'm sorry, a prosecutor signed it,
Yes.
so who needs to swear to it? The officer, well, do you know what officer has it?
Your Honor, you have all the information we have. Our system indicates the charges were authorized and it looks like it still needs to be sworn to.
The reason why I'm asking is I'm on call this week and it would go to me, so I could do it right now. We can take care of it right now. If we could track down the officer. Oh, wait, everybody's calming down. No, that's a writ. I don't have anything this week from him, in reference him, so no one's forwarded to me.
Or maybe it hasn't, maybe, I don't know, maybe the warrant hasn't been typed yet. I'm not sure. Do you have the warrant?
Well, if a prosecutor signs, typically what happens is the officer sends it to the prosecutor's office, they sign it, and then it goes back to the officer, then the officer's got to send it to us. There's been a delay sometimes, depending on the officer, with them actually sending it to the court. Case in point, yesterday, I did receive a complaint that was signed by your office over 30 days ago. I received it yesterday.
I don't know.
The
who
officer's gonna now say
is
that the
or-
court held it. I immediately forwarded it to administration. That's typical. I don't know what the delay is. But if it's been signed by your office, that means the officer already brought it. The officers are the ones that bring you all the charges. So if Mr. Pfeiffer has already signed it, then it should have gone back to that officer to go to a judge to authorize the charge. And so, is Mr. Pfeiffer in the office today?
I don't know.
I will reach out.
Can you send an email to see if we can find out what officer is supposed to have had this? Because if that's something that they can send me today, then I can get it signed today. That's the best I can do.
That's the hope, Your Honor.
And because you're saying this is something from allegedly from July, this is not a reissue though, correct?
Not that I see.
Okay, this is a new issue. It would have been from July, and you're saying it's the same victim. Correct.
It's something we could probably do in these cases.
Does the victim ever appears?
I know.
Okay, so we'll get it signed, and then your attorney, I'm sure, will request a final plea trial. Or I don't know if it's a felony or.
I think it's a felony.
Okay, well, then we'll see if they appear for the examination. But if I can at all get it sent to me today, I will have it entered while you are downstairs, have you arraigned today, if possible, okay? Look, give us an opportunity to see if we can get Mr. Pfeiffer to provide us with the name of the officer who issued or requested the charge, okay, sir? Thank you. Mr. Goodrich is back from the breakout room.
Yes.
That was all my files. I'm done with my file. I think. Yes, okay. 48 hours. Who? Me? Yeah, I gave it to him and said 48 hours for her because was one she says she usually speaks to her, I guess. We'll see. Let's see, State of Michigan versus Elmer, Salvador, Regaldo, and this is 26-00475. Appearance, please.
Ross March, meet up for the people.
An attorney, Luke Goodrich from the Public Defender's Office, here to represent Mr. Salvador Regaldo. And Your Honor, I believe we need to have the interpreter sworn in.
He's got to state his name for the record.
First name Jorge, last name DiFurno, Jorge, last name Difurno.
Raise your right hand. You solemnly swear or affirm to interpret in the matter before the court completely, inaccurately, and not divulge confidential communication.
I swear.
Thank you. Okay, this was a probable cause conference that was scheduled before Judge Buchanan.
Esta es la conferencia de causa probable y se había hecho inicialmente con con el juez Buchanan.
And this is for an assault harm charge. It has an exam for the 26th of March.
Y este es para el cargo de asalto con arma para el 26 de marzo
At 10 a.m.
a las 10 de la mañana.
How are we proceeding?
¿Cómo procedimos?
Your Honor, we would like to leave the matter set for preliminary exam.
Su señoría, continuar la situación para el examen preliminar.
Okay, this matter will continue to examination in person next week. Now, does Mr. Salvador Regaldo have any questions for the court?
El tema va a continuar para el examen preliminar la semana siguiente en persona. ¿Alguna pregunta, señor Delgado?
Y no, solo espero que todo salga bien, primero Dios.
I'm just hoping that everything goes well. God first.
Well, amen to that. Any additional matters for the record?
Nothing for the people.
And nothing from the defense, Your Honor.
Ya,
Thank
ambas
you,
partes
Your
dicen que no tienen nada que agregar. Ya continuamos para la semana que viene.
You're all set. Thank you.
Ya está todo cerrado. Gracias.
Thank you, Your Honor.
No problem. Has anybody seen Daniel Auka?
Your Honor, I'm here on that matter. Mr. Auka is in treatment. I can address that on the record. I'm the attorney.
Mr. Salvador Regaldo, you're all set.
Señor Salvador Delgado, ya hemos concluido por hoy. La semana siguiente continuamos y va a ser en persona.
Muy bien.
Gracias. Thanks.
Thank you.
Gracias.
Are you ready to go on the record?
I am.
No, I know. I am absolutely sure you're not driving. I'm absolutely sure.
I am pulled over right now. That's why I was delaying turning on my video.
On the record in the matter of the state of Michigan versus Daniel Auka to 6-00537 FY appearance, please, or FD appearance, please.
Ross March, meet up for the people.
And good morning, Your Honor. Joshua Nushin. I'm here on behalf of Daniel Auka.
Okay, this matter was scheduled for a probable cause conference before Judge Buchanan. This is for operating while intoxicated third, driving while license is suspended second, and an open intox driver. The defendant is not here, and why is that?
Yes, Your Honor. So, Your Honor, I was informed last night that Mr. Auka was admitted into an inpatient treatment facility in Abbottstown, Pennsylvania, called Innovo. That's INNOVO. I received email communication from Innovo this morning indicating that he is in treatment there. They're requesting that he not be pulled away from treatment while he's there, and they expect him to stay the full time of 45 days.
How did he end up in treatment in Pennsylvania?
His family arranged and there was a bed available and they took him for treatment as I believe there was an immediate need for it, Your Honor.
Okay, the reason why I ask is because that's a violation of his bond to leave the state without approval of the court.
And I know the family was fully aware of that. I reminded them once I found out that the treatment was going to be in Pennsylvania. And they said that he needed to get the help as soon as possible. I was retained on the case on the 17th, and he ended up in treatment in Pennsylvania yesterday, the 18th, Your Honor.
If the family felt so strongly, why didn't they seek a request to have his bond amended? Did the family believe that they're above the court order?
Your Honor, I can't answer that. I don't know.
Okay.
And I advise that there's a likely going to be a warrant issued today based on that, non-compliance of this honorable court's bond order.
Okay, this matter is supposed to proceed to a preliminary examination on the 26th. And so is he going to appear via Zoom from wherever he is for a probable cause conference next week?
Can we have a probable cause conference, and I will speak to the facility and make sure that they have to have him appear on that day.
Well, I guess I didn't, it was communicated to me that he was in an inpatient facility. I didn't realize that he left the state in violation of his bond, and people are going to request a bench warrant, honestly, and have him turn himself in Michigan. He drove drunk in Michigan, caused an accident in Michigan. He can't leave Pennsylvania and decide he's going to do inpatient care while having court dates here.
I mean, I would agree that it's a concern that he has left the state and outside of the court's jurisdiction without the court's permission like that. He was aware of that, and then obviously his family was aware of that. And so I don't at any point deny that if someone is obviously facing and operating while intoxicated, third offense notice that they are in need of some treatment. But we have plenty of treatment facilities here within the state of Michigan. That's first and foremost. B, that doesn't absolve you from the fact that you have a responsibility to appear for your court dates and to follow the court order. And if there was the only viable treatment option was in the state of Pennsylvania, then he should have followed his attorney's recommendation, follow the court order, and made himself available to the court to make a request to leave the state for this purpose. And now he wants us to allow him to stay there for 45 days, and then who knows, start a new life in Pennsylvania when he's done. I don't know. I don't know what he's doing in Pennsylvania. You had something you wanted to add?
I was going to note that the people were going to be offering sobriety court in this, and I feel confident that were he in Judge Buchanan's sobriety court program, that he would not be allowed to do his inpatient treatment in Pennsylvania. I feel confident he'd be required to do it.
I'm confident as well. Nonetheless, I will note that was the offer. I don't know if the defense counsel was previously made aware of that, but that has been stated here.
I was, Your Honor.
Okay, I'm going to note here that the defendant has failed to appear. You're retained on this, counsel?
I am, Your Honor.
I will grant him a courtesy that he's not shown himself worthy of at this point. And I will treat next week as a probable cause conference before Judge Buchanan. I will let her decide the issue of the violation of the bond. If she wants to issue a PA 53 or a bench warrant for that purpose, she can do that. And that's only under the circumstances that he's appearing next week himself from the treatment facility. Okay, so we'll treat next week as a PCC. He must appear virtually and then waive his timeline if that's what he'd like to do.
Okay, thank you, Your Honor.
And then I have noted here that the judge of record will address any bond violations.
Okay, I will call the court and get Judge Buchanan's Zoom information and
It's
reach
on
out
the
to
court
the
website.
Okay.
Just for clarification, my understanding is that his bond condition does still require him to. I guess my question is he allowed to stay in Pennsylvania?
He's not allowed. It's a bond violation. So I'm leaving it to Judge Buchanan if she wants to issue a bond violation. I can't arraign him on one anyways, because he's not even here. If so, the PA 53 will be issued from her court, and then he can be arraigned next week.
Okay, thank you.
No problem.
I would know, I'll reach out to Judge Buchanan's staff about whether or not she'll require that he appear in person at the PCC.
Sounds good. Thank you.
And Ross, I will reach out to you this afternoon. Thank you.
Thank you.
That's all we have. Thank you. Don't drive and do court.
I
Against the
will.
law.
Thank you.
Oh, I think we need an appearance from you.
I sent one in yesterday. Should have it. Appearance and discovery request. I sent it over to the 54A email.
No, that's why. Well, let's see if they can access that email. Okay, thank you.
Thank you.
Bye.